There is probably no one who has written more and focused more on the Voting Rights Act in journalism than Paul Blumenthal. All you got to do is put his name into Google and you'll pull up dozens, I think, of articles dating back years, keeping a close eye on our Voting Rights Act under attack by the Roberts Court, starting 12, 13, 14 years ago. And it now has all come to a head with a case that's now been put on the docket with a briefing schedule and a question to be answered that sent a chill down anybody's spine that worries about voting rights, people's right to vote, and representation represented by congressional maps. It's the case, I don't know if it's pronounced Calais or Callis. I think Callis is the right way to pronounce it. Callis versus Lindsay, which is up for the Supreme Court. And Paul Blumenthal, the reporter for the Huffington Post, of course, is on the beat about this case. In a new article he titles, "The Supreme Court may be about to deal a final blow to the Voting Rights Act, specifically Section 2. And I have, to brief our audience, of course, the author of that article and so many more on voting rights, Paul Blumenthal. Paul, welcome back to Legal AF.
Hey, thanks for having me.
Yeah. So you and I are always on the same wavelength. I read your articles and I'm like, we got to bring Paul on. And then right away I see in my email box, maybe I should come on and talk to your audience about this. And here we are. So it's easier for me to sing your praises. I don't think anybody's got a body of work the way you do in keeping a close watch on and as a sentinel for the Voting Rights Act. The Voting Rights Act, as you so eloquently put in your writing, which was born from or signed by and finally passed by Lyndon Johnson in 1965, immediately following Bloody Sunday on the Edmund Pettus Bridge, when a combination of John Lewis and Amelia Boynton and others were almost killed standing up for civil rights by the then Alabama sheriff or police chief Jim Clark and others. We've seen the images of it, both the photos that have been released and in the movie Selma about this issue. And that led directly to August of 1965 when the Voting Rights Act was eventually passed. And ever since, at least in the last 20 years or 15 years, the conservatives, now MAGA, have been chipping away at the Voting Rights Act. Clarence Thomas hates it, has always hated it. He's always waited to have the numbers to try to get rid of it. John Roberts has written all the major decisions, not just chipping away at it. There's only one thing left of it. Section 5, which dealt with pre-clearance, meaning mainly the southern states that had been abusive over voting rights, had to have things like maps and other of their rules, had to have a judge sign off on it. A lot of them, they didn't sign off on it because they were still blatantly racist. But the Supreme Court, led by John Roberts, got rid of Section 5 effectively of the Voting Rights Act passed by Congress, leaving really only Section 2 left. Paul, why don't you take it from there? Talk about the premise of your article, what you're finding, and how you set it up for what could be we say this a lot, but this could be the pivotal case next term. If you think voting rights and representative democracy matters, this is the case you need to follow.
Well, yeah, I think to start, let's just look at the history of this case to see how important this the coming term will be for the Supreme Court. This case was based on a series of cases that came out of Louisiana challenging the maps as racially discriminatory for failing to draw a second Black majority district. District courts, appeals courts found that the state needed to draw a second district, and a similar case out of Alabama went to the Supreme Court where they said that Alabama had to draw a second Black majority district. So then that kicked it back to Louisiana. They drew a new map. What they wanted to do in complying with the court's orders was also protect their incumbents, Mike Johnson in particular, the Speaker of the House. So they cut up this new district that stretches all the way from Shreveport to Baton Rouge across the state. Looks a little weird, isn't totally compact like you think of. And they drew a second Black majority district. Then a group of who they call themselves non-African American voters, which I think is a mix of white people and Creole people, challenged the map as racially discriminatory for drawing this oddly shaped district and denying them the right to their own representation. The Supreme Court took up that case, heard arguments earlier this year, and then never released a decision. They punted on it at the end of their term in June and said, well, we're going to rehear this case, but they didn't say why until last Friday evening when they released the question. And that question is whether Section 2 of the Voting Rights Act as it applies to redistricting is unconstitutional under the 14th and 15th Amendments. And, that could sound ridiculous to a lot of people, and I think it does, that, trying to enforce the 15th Amendment, which, requires states and governments to not racially discriminate in voting in elections, that the Voting Rights Act somehow violates that instead of enforces it, which was the point of the Voting Rights Act, seems absurd. But that is the question before them. As you mentioned with Clarence Thomas, that is what he has said all along, going back 30 years since he's been on the court. And now we have, the real issue here is that the Alabama case that I was talking about was decided 5-4 with the 3 liberals and Roberts and Brett Kavanaugh. But Brett Kavanaugh was also interested in what he calls the temporal argument raised by Clarence Thomas, which that Section 2 should have an end date, even though in Shelby County, the decision that Roberts wrote that killed Section 5, he called it permanent.
Just stop right there, because I want to catch our audience up. Why does an act of Congress, where it doesn't have what we call in the law a sundown provision that says it should end at some time, why are we having a Supreme Court graft onto legislation language for a temporal end at some certain time of their choosing that doesn't exist in the legislation? And why isn't that a violation of the Supreme Court's own major questions doctrine? If shouldn't they be going back and waiting for Congress to speak about the Voting Rights Act and not have elements of it legislated out of existence by a judicial fiat decree?
Yeah, I think that exactly hits the nail on the head. This would be lawmaking from the Supreme Court, not interpretation. What they're looking at is the Voting Rights Act was renewed in 1982 in response to a decision that restricted how it could be challenged. And in 1980, that 1982 decision laid out, or that 1982, renewal of the law, reauthorization, laid out the reasons and the justifications for Section 2's continuance. And what Kavanaugh and Thomas have said, particularly Thomas, is that those justifications, from the beginning, didn't, really matter or mean what they actually meant and didn't justify this law. And B, that, they have an end date. That's no longer what's going on in the world right now.
According to Clarence Thomas.
According to Clarence Thomas and possibly Brett Kavanaugh. And we also have, the other conservative justices who joined in opposing, the Alabama case, filing a dissent with Clarence Thomas as well, So, there's 4 of them and maybe Brett Kavanaugh. So that's the real danger here, is finding that Section 2 would be unconstitutional. And, that poses such a huge danger to the right to vote and to equal representation across the country.
So to brief our audience, you've got amendments that come out of primarily the Reconstruction period of America, the Reconstruction amendments after the Civil War, 14th, 15th, and all of that. And then you have Congress at various times, including in 1965 and 1982, putting some meat on the bone, some statutes, to effectuate the goals and the policies of the amendment, right? Because in the great rock paper scissors world, Constitution and constitutional amendments beat statutes, and those should both beat executive orders. But here you have something that's been on the books since 1965, been affirmed over and over and over again by courts not named the Roberts Court. And then you had, as you pointed out in your prior reporting, you've got the chipping away of it. They rip away one major leg of the stool, right? Section 5, gone. We're no longer going to babysit racist states who historically, there was a reason we had to keep an eye on them, because if they were left to their own devices, they passed laws that were the effective equivalent of poll taxes and literacy tests for voting. And then they carved up their state. When we talk about maps, we're talking about congressional maps. They carved up their Congress maps in a way that denied representative voting to minorities. So they're not screwing the white guy or the Creole, they're screwing the black person and the brown person. As an example, in Louisiana, it is 1/3 black, as you point out in your article. And there was, until this only second district, only 1 out of 7 districts. So 1/7 of the state had a black or minority majority district, and the 6 others didn't. So how do you map on with straight face 1/3 black onto a map that looks like lily white, except for one small little box? And so it's weird now, right? Because the parties that are aligned together is Louisiana, which historically had been pretty racist, is now aligned with the NAACP and other black groups to defend the map against this challenge. But to be honest, the Supreme Court MAGA right wing, they don't care about who's in front of them, because they don't care about cases and controversies anymore. They just want to make new law, apparently, because they have the numbers. And so they really don't care. Let's be frank. They really don't care anymore about, you hear it. You've heard Alito, and I'm sure you've listened to the oral arguments. You've heard Alito and others say, let's not get bogged down in the facts of the case, because it makes it very confusing for us to make the law. And I'm like, are you not the Supreme Appellate Court? You're not going to get bogged down in the facts and the record? So they don't care about that. It's what has been presented, as you just said. And when you see how they frame that question, right? That was the intentional inclusion of a minority district in Louisiana, a violation of the 14th and 15th Amendment. It's just dripping with it's just pregnant with it. Well, that's the wrong word with this court. It's just dripping with where they're likely to end up here. And how many times at the oral argument the first time around did Brett Kavanaugh say, well, let's talk about temporal. Let's talk about the time and the expiration date on this, as if it was a carton of milk in your refrigerator.
Yeah, I mean, that was Brett Kavanaugh's main focus there. I mean, I think that, as we've seen a lot from the reaction from the voting rights community, from voting rights experts, law professors, they see the presentation of this question as the biggest threat that the Voting Rights Act has ever faced. And that threat means, the potential loss of Black and Latino representation at, a level we haven't seen since the end of Reconstruction. I mean, we're talking about the potential retrenchment to the days before the civil rights movement, where Black people, particularly in the South, they might say, times have changed, the facts on the ground are different, thus that we have to look at this temporal argument. But if you look at the states that are frequently challenged, see their maps get struck down by courts, it's the Deep South. It's the same states. That were covered by Section 5 before. That the reason why this law was put in place. So times haven't changed as much as we like to think, or the Supreme Court may want to rule. No,
I was going to say this is Mississippi burning. I mean, the 1965 is meaningful to me because that was the year I was born. I was born a little bit later in that particular year. But, MAGA and the right wing want us to believe that we live in a post-racial world. We elected a Barack Obama twice, apparently, and that was enough that was it. That was all. That's all we're entitled to now. You wrote in your article, which I commend everybody to go read. We'll put the link down here in our notes. You quote Nicholas Stephanopoulos, a law professor at Harvard, and here's how you lead into that. You say, a decision that declares Section 2 unconstitutional would leave the act toothless and threaten the existence of minority representation, particularly Black representation, across the South. And then quoting Nicholas Stephanopoulos, he says, if this goes the way it looks like it's going to go, it's going to be Shelby County on steroids. I'll have you explain that. This is going to be the single most catastrophic moment for minority voters since the 1870s or 1880s. You want to amplify that?
Yeah, I mean, so the Shelby County on steroids, Shelby County was the decision 12 years ago that struck down Section 5, which was the pre-clearance regime where states with a history of racial discriminatory election practices, namely the Deep South, but some other places as well, had to submit their district maps, their election laws that they wanted to change to the Department of Justice to be approved under the Voting Rights Act. That was struck down. Immediately, these states moved to try to change their laws, redistrict, but a lot of that was held back by Section 2. So now Section 2 goes away. There's nothing. There's nothing standing in the way. Theoretically, there's challenges that could be brought under the 14th or 15th Amendment, but the Supreme Court has already made those so difficult that it's almost meaningless. But what this would mean is, and especially even before the 2026 elections, because this is going to be argued in October, and a decision could come out this year striking down the Voting Rights Act, calling every state that has adopted a map under the Voting Rights Act, illegal, which would mean these states might have what they would call a good justification to redraw them ahead of 2026. And there are 11 Black majority districts in the Deep South right now that could be completely eliminated. And then, you go down the map to state legislatures, to city councils, to county councils, county commissions. There are so many elected offices that this plays a role in allowing Black and Latino representation. Mostly this would be challenged across, this would affect the South, but, Section 2 is a national law. Section 5 was not. Section 2 covers the entire country. And so you could see this in other places where Republicans hold power.
And take it to the next step. You got 5 seats being eliminated in Texas. You got 11 seats being eliminated potentially by this Supreme Court decision, which they seem to be rushing so they avoid what they refer to as the Purcell Doctrine, because giving themselves enough time before the election for the maps to take effect. That's 16. That's handing MAGA and Donald Trump 16 seats. We haven't even run the election yet. So you see how important this thing is. What we try to do here in Legal AF, and you do so well in your writing, is to take these kind of esoteric concepts that sometimes can be mind-numbing. When we talk about, voter disenfranchisement, I try not to use that phrase anymore because people can automatically go off to the dentist and get a root canal without Novocaine when you start using these terms. So when you talk about your vote is being tossed into the trash, the maps about Congress and other things, and your ability to have somebody represent you is being thrown into the wood chipper, then it brings it home. And I think that's why you have these amazing headlines and then the detail in the writing as well. I was going to ask you a last question here about it. Well, why do you think, I understand why Kavanaugh, I definitely understand why Thomas is in that camp. And Kavanaugh's quickly sliding over to all things. There's this unholy alliance of Gorsuch that's developed in the last year of Gorsuch, Kavanaugh, and Thomas, along with Alito, of course, was always there. But why do you think Roberts has a problem with making sure that we have a representative democracy and that Black and brown people feel like this country and its elected officials represent them? Why does Roberts have a problem with it?
Well, Roberts, the interesting thing here is that Roberts isn't even the swing vote. He was in the majority in the Alabama case with the liberals and Kavanaugh, and he wrote that opinion. Kavanaugh was the one in a concurrence who raised this temporal argument as something that should be heard in the future. But Roberts does have this very long history of antagonism to the Voting Rights Act, going back to his time as a junior lawyer in the Reagan administration. He was the one who was trying to get Congress to not reauthorize it in 1982 from within DOJ. He was writing memos opposing the Voting Rights Act as an intrusion of the government into the state's business. And, echoing sort of what, maybe not to the degree that Clarence Thomas does, saying this messy business of sorting us into different racial groups, that needs to end, as a means to some kind of national community. But I don't think that his vote even really matters here if it's just all about Kavanaugh. but he did write the majority in Shelby County. He has long been an opponent of the Voting Rights Act. I wouldn't be surprised to see him join a majority here that strikes it down.
So who do you think the swing is? Who do you think the swing is?
The swing is the only swing is Kavanaugh, really. After that, it's all, icing on the cake for them.
Yeah, because you see Amy Coney Barrett going over there.
Well, she was in the Alabama case. She was with the dissenters, with the other conservatives. So, I think that she would already be there. I don't see any other reason why not. Right. And if we look at it from Robert's long career here in the law, this has long been a project of the conservative movement, the conservative legal movement, killing the Voting Rights Act, maybe even killing the Civil Rights Act itself. And, this was entrenched into the judicial branch because they felt like they would never be able to do this legislatively or through, electing a majority. And so they had to do it through this means that is protected from democracy, through a judicial ruling. And it looks like that's what's going to happen this October.
Yeah, listen, I think we need to call it out now. The bridge is out ahead, as we say, on the road. And rather than wait around and report on, well, it was a difficult oral argument today. It looks like we want to talk about it now in August. And I think that's what your purpose was in the dog days of summer, to kind of get this out there. Listen, we know if Donald Trump, I'll say it, you can just I'll say it while you're with me. If Donald Trump was the president in 1965, not only would the Voting Rights Act not have been signed, but he would have arrested John Lewis and had all of those people arrested and put in jail, and he would have applauded and celebrated the cops that beat them with batons and other things. There's no other. Just map Jan 6 onto what happened on the Edmund Pettus Bridge, and we know what would have happened in an alternate Earth had Donald Trump been the president at that time. And now, so our audience is going to ask what we can do about it. The closest thing I could think of, besides continuing to train focus on this and pressuring the Supreme Court, because they do read the paper and they do watch podcasts and other things, is that we got to regain the Democrats have to regain the House and hopefully the Senate, and have to reinstall the guardrails and a new Voting Rights Act. John Lewis was working on that for years until he passed away finally. But we have to have a new Voting Rights Act and Civil Rights Act passed by a proper Congress. And then we're up and running. I know there's no other solution. If we get a terrible ruling, it goes to the states. If they want to have no black representation in their state, that's fine by us. If that's going to be the ruling, then we're going to have to take matters into our own hands in terms of, getting the House and the Senate back and doing the right thing and passing yet another 60 years later, yet another Voting Rights Act, right?
Yeah, I think that the only response to a decision like this would be legislation, whether it's, reauthorizing the Voting Rights Act on new terms, a new Voting Rights Act, or of course, any kind of legislation aimed at changing the judiciary. Yeah,
also that. Paul Blumenthal got an amazing article out on Huffpo. We're going to put the link to it down below. You'll know everything you need to know on this very important issue about how Voting Rights Act Section 2 is on life support and what we can do about it. Paul's joining us on a regular basis now with some of his reporting. I'm sure there's other things that I don't know what you're writing about, but I'm sure there's other things that will be of interest to our audience. Right after this and later this weekend, I'll have an interview up with Robbie Kaplan about the same-sex marriage ruling that seems to be under attack, and whether there's the numbers there for that. She had argued aspects of the case and DOMA before, so I wanted to hear from her. But these are the important things, even in the doldrums of the summer, and how the Supreme Court sets its docket, its agenda, it frames their questions, all very, very important. Paul Blumenthal, thank you so much for joining us on Legal AF.
Yeah, thanks so much for having me again.
I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touches Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event, by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok firm, fighting for your justice every step of the way.